around the law for duty to protect, just to get a background in there. And let me ask first, does anybody have a case they want to talk about? Because otherwise I can talk for the whole 3 hours on this. So, so I don't want to, I'll just skip some slides. You'll get all the slides later anyway. So any case, anything? Bueller, anyone? Okay. All right. Well, then I will share my slide set here and we can go from there. Because there's a lot here. And in fact, as I talk about this, you'll see that this actually applies to every one of you, because under the Ohio law, you are all considered to be a mental health provider. So this law actually affects you. The good news is that the Ohio law is great. The Washington state is going the wrong direction. So let's just jump to that. No disclosures. This is what people think about with psychiatry and the law. How much do you charge for your legal services? I charge $10,000 for 3 questions. Kind of steep, don't you think? Indeed it is. What's your third question? So this is what we all worry about when we interact with attorneys. And in fact, I was in our executive director's office yesterday. We're working on some stuff with attorneys, and our CFO came in to explain that we had overspent what was actually a very small budget for attorneys, so we have to add to the budget. So this does concern people. So let me just jump to the main part here. So under U.S. common law, no person is responsible for the violence that a second person inflicts on another, call that the third party, unless a special relationship exists between the first and second. Well, in this case, in the United States, a therapist-patient relationship. So again, LPCC, LISW, nurse practitioner, psychiatrist, what have you, with the patient is a special relationship. So there is, therefore, an underlying obligation here under U.S. common law. Some of you may have heard of the Tarasoff case. This is Tatiana Tarasoff. This is Prosenjit Podar. And back in 1976, they actually had a 1974 decision that got vacated, and they had to redo it at the Supreme Court of California, which is unusual. But to do something like that, but I jump into save some time here. So Prosenjit Podar did kill Tatiana Tarasoff, and many of the laws you'll hear out there, duty to protect, you'll often hear them referred to as Tarasoff laws. So that's why I wanted to give you this quick background. So they went on one date, they kissed, and culturally and perhaps psychotically, Mr. Podar believed that they were married, or at least had to get married. He was very bothered by this. She was not returning his affections beyond that date. He saw the school therapist. He did indicate he was really upset, thinking about hurting her. And of course, the police did talk with him, which was good in those days. That was ahead of their curve in that respect. They didn't think there was any real danger. However, he went on to kill her. The psychiatrist over the summer said, you know what, I'm a little worried that he killed this woman, and we had it in the record. So let's destroy all the medical records. Please don't do that. Most of these big cases, some egregious act like that was done. And of course, not surprisingly, Tatiana's family sued. So again, they came up initially with a duty to warn in 1974. That wasn't really good enough. It didn't work very well. So they actually redid the case. Again, very unusual at a state Supreme Court level. And then they did this duty to protect. And I'll explain the difference real quickly here in a few minutes. But what they said in Tarasoff was that when a therapist determines, or according to the standard of his, her, now we could add their profession, should determine, this is important, that his or her or their patient represents a serious danger of violence to another, he incurs an obligation to use reasonable care. Again, he, she, they incurs an obligation to use reasonable care to protect the intended victim from danger. That's a pretty high bar, actually, right? That's, oh, okay, how do we do that? They did not say a lot. They did indicate a few things. You could talk to the police. You can warn the intended victim or others who might be able to tell the victim about the danger. And then the, not very helpful, take whatever other steps are reasonable, right? So nobody knew what that was in California, let alone anywhere else. But it was specifically a duty to protect identifiable potential victims. And that's going to be key to pay attention to the subtleties here as we walk through these. So extensions of terror stuff. So after that case, you started to see other states where people sued because a therapist did not protect a patient from, a third party from a patient of the therapist. So you notice here, this is intentional harm, unidentifiable victims. That's pretty scary. Notice a weird one here, Lipari versus Sears and Roebuck. Well, guess what? Lawsuits. You always sue the deep pocket. They bought the shotgun. Mr. Lipari bought the shotgun at Sears and Roebuck. And so they sued, the family, through the attorneys, sued that. You notice that he shot randomly into a nightclub, harming others. So this new law that in Nebraska, again, only in Nebraska, that doesn't mean it's true everywhere, but every state watches this stuff, extended the terra idea to unidentified third parties. So we're going down the literal slippery slope here. Notice here, Peterson, this is key because we're talking about a Washington case in the one that Nicole sent out in advance. So it's 1983, duty to protect unintentional harm to unidentifiable victims. So the person didn't even mean to hurt anybody. He was discharged. He had PCP-induced psychosis. Turns out he also had a substance use disorder, and they knew that in the records. He was seen driving erratically in the hospital parking lot before he was officially left the hospital. They did nothing about that. He ran a red light and struck Mrs. Peterson's car 5 days after discharge. They sued for the harm to her, and they found, in fact, that this hospital was liable because they didn't protect this unidentifiable victim from unintentional harm. Because, by gosh, he had he was driving under the influence at the time, and they didn't protect her from his substance use. That's a pretty slippery slope. As we walk, I'll end it with this. You can see how bad it gets here. So Peck versus Counseling Services of Addison County, I believe that's Vermont. The outpatient, now not even an inpatient who has had, you have pretty good control over inpatients and got discharged. Outpatient made threats to burn his father's barn, and then he did it. And the parents were very upset. So they sued the counseling center, and they were held partly responsible because they apparently angered the patient some way. However, they did find that Addison County Counseling Center had a duty to protect objects from harm by the third party. That's about as slippery as it gets, right? And oh, by the way, most of these cases initially started with psychiatrists, and now you see it starts to extend to all mental health professionals. So unfortunately, some of these cases are not this blatant. Dad, can I borrow the gun tonight? Right. So that's not quite that obvious as to what's going on. So by 1988, 18 states started to react to the slippery slope and said, hold on, this is getting out of hand. We need to solve this before it gets too far. Unintentional harm to unintended objects would be the next step. And that's, what do you do with that, right? You get angry, you punch the wall, then the family sues because you need $300 to fix the wall. I mean, you can see how that would become a slippery slope. So what they said was that in these 18 states, that if a patient has made a serious threat of physical violence against a reasonably identifiable victim, so they rolled it back to the simpler version of this, the much less slippery slope, then they had ways to do this, and we're going to talk about how that applies to Ohio in a moment. So in Ohio, they passed a law in 1999, which actually happened to be within a year of me arriving in Ohio, and I'll explain why that's relevant in a minute. But so no person shall be liable for any harm that results to another person as a result of failing to disclose confidential information about a mental health client or failing to otherwise attempt to protect such persons. So the goal here is to try to get more protective. There was no general duty. This is pre the 1999 law. There was no general duty, same as the common law in the United States, unless there was a special relationship. Well, guess what? That was here. And of course, that got expanded over time by the Supreme Court. So we then had two cases in Ohio that are relevant. And I know I'm going fast, so we can come back to questions if you want. But so 1988, again, before I arrived here in 1998, And then this law passed in 1999. So we had this case. Now, this is a hospital. So the concept here is that you, in the hospital, the treatment team has a pretty good amount of control over the patient, right? They're not going to go out and hurt somebody unless they escape. And that, of course, would be a big problem if they did escape and do that. So Miss Pearson was voluntarily hospitalized. That's important as well for postpartum depression. She did say she didn't love her newborn. She wanted to give the baby away. And on discharge, they arranged a plan where the patient would only have supervised visits with her infant at a relative's home. That's important in this case, a relative's home, not a therapist, not a supervision of a treating person. 2 weeks later, she killed the newborn with a fatal dose of aspirin. Horrible, horrible situation, and it was intentional. So they did say, well, again, it went through, it starts, just to reiterate that in case you don't listen to that stuff since social studies in high school, it starts at the local court. It can then go to an appeals court, and then it can actually go to the Ohio Supreme Court. Anything beyond that would go to the United States Supreme Court. That's rare because they get to choose their cases. So they often say no because they're busy. So the Ohio Supreme Court said that a special relationship did exist, right? The psychiatrist had control, that was their word, of the patient in the hospital. Therefore, there was a duty to protect potential victims. And in this case, of course, the infant was an obvious victim because it was being discussed throughout the medical record, because that's what courts look at. They look at these records and testimony. And they said that the psychiatrist could have fulfilled, I don't actually know if it was he, she, or they, but fulfill the duty by completing a thorough evaluation of violent propensities. This is key, the balancing test, balancing the interests of the patient and society, in this case, the victim, the baby, in formulating a treatment plan and then making a good faith judgment. So they call this the professional judgment rule. So this didn't get a lot of fanfare in Ohio. This was like, oh, that makes sense. Pretty extreme. They let her out, that she didn't have anybody really watching the baby. It was family. Family obviously loved the woman, so they're not watching her that carefully. They don't realize the possible risk, and she ends up killing the newborn. It gets worse. 1997, notice the date, so that's why I say 1998, 1999 in my mind are key. So Morgan versus Fairfield Counseling Center, there was a patient with schizophrenia, prior hospitalization, so a history of illness and serious illness, goes to the counseling center. The treaters basically, and the records show this, ignored that the patient's parents made complaints. He was getting worse. He was becoming more and more violent. Nothing was done. They didn't change the treatment plan. They didn't do anything differently. And the patient did kill his parents. And seriously, he tried to kill his sister. He did not succeed at that while he was still under therapy. So again, all the way up through the Supreme Court of Ohio. And it said, of course, there was a special relationship. And they said those outpatient has elements of control. They didn't give it the level of control in the hospital, but therefore there is a duty to control the patient and protect others. Same test, that professional judgment standard of balancing the interests of the patient and society. And that overrode this immunity provision that I showed you, right, saying you didn't have any obligation. So now you're in trouble. Right now it's fully eroded, both inpatient and outpatient. And they said at the time, again, this is 1998 or 1997 rather, when a psychotherapist knows or should know, go back to looking at what we saw with Tarasoff, that his patient, again, his, her, their outpatient represents a substantial risk of harm to others, the therapist, so not just psychiatrist, therapist, must exercise his, her, their best professional judgment to prevent such harm. And of course, the implication there is you would document your plan, as has always been the case. This was, of course, the reaction of therapists everywhere in Ohio, right? This is sort of like managed care. It's sort of like an appearance, but I need to order a battery of tests because now there was this fear, this defensive medicine ratcheted up in Ohio. So I entered the state in July of 1998, coming from Maryland, and I heard all this hubbub about this. Oh my gosh, oh, this is horrible. And I'll tell you later, I'm going to do the DeMeerleer case first, but I'll tell you what we did about it in Ohio, because Ohio actually did a great job resolving most of this. So we can all rest pretty easy by the end of this talk, because you're probably all a little jazzed up now. So the simple case, this is the case that Nicole sent out to you from Washington State. So Mr. DeMeerleer murdered Ms. Shearing and one of her sons, and then actually took his own life, died by suicide, July 18th of 2010. The surviving son, the one who survived, sued Dr. Ashby, who was the outpatient psychiatrist who had treated Mr. DeMeerleer. I just wrote DM from this point forward, because it's not as simple as Smith. So made Mr. DeMeerleer until 3 months prior to the event. So there was a gap in care. The notes showed no evidence that Mr. DeMeerleer might be violent towards self or others. That was never part of his care, never part of his case, never part of consideration by Dr. Ashby. And from most of our accounts, we'd be thinking, yeah, so who cares? I mean, great. Glad he wasn't having these problems. Well, the trial court, I'm going to walk you through how this works. The trial court said no liability, which I think all of us would be like, yeah, that makes sense. Why would he be liable? Through no treatment in 3 months, which meant the patient wasn't showing up. No evidence prior to that he was a danger to himself or others. Trial court said, yeah, but they took it to the appeals court. So that what happens then is the side that doesn't like the opinion takes it to the appeals court. That happens in Ohio as well. Goes to the appeals court. Some of you may know Tom Teodosio from Akron, who for quite a while was on the appeals court here in Ohio. He actually got bumped off the last election, unfortunately, because he's quite excellent, as is his wife, who is still the head judge for our family and youth courts in Akron, so in Summit County. Anyway, so the appeals court cited an older case of Volk. So when you see this, never mind. When you see the case, that I think the article is titled Volk versus DeMeerleer, it's really a play on words. It's not actually that Volk was suing DeMeerleer or vice versa. It actually is two different cases, and they're comparing, but because they're lawyers who wrote it, they're comparing Volk versus another case, DeMeerleer. So just be aware that that is not, if you try to look that case up, I'm sure several of you did that, I'm kidding, to figure out it's not a case. It's two cases. So they have this case in 2016, again, Washington State, where we saw the Peterson case of the unintentional harm to an unidentifiable victim, right? Driving erratically in the parking lot and then hitting her at a red light. So they said in that case that an outpatient mental health clinician, and this is a quote, incurs a duty to take responsible precautions to protect anyone who might foreseeably be endangered by the patient's condition, even if they never voice such information and the clinician has no control over the patient. So based on precedent, which is how cases work, they try to keep the same opinions going forward if an opinion was rendered in a prior case, and actually at least at the appeals level, or certainly at the state Supreme Court, and definitively at the federal Supreme Court, they hold that precedent. So they actually, using that, said, nope, Dr. Ashby is liable. They went to the Supreme Court because, again, Dr. Ashby's attorneys appealed it, and the Supreme Court actually upheld it. There was a little bit that they didn't uphold, but basically, just to make it's a very complicated argument, they ultimately still upheld that he was liable due to the Volk case in 2016. So this raises big issues. I'm going to mention AMA ethics and APA ethics. They refer to some of this in the article. So patients, of course, and I'll just paraphrase all this, but obviously we want our patients to talk to us. We need us to tell us the information that will help us to help them. And we also all know as therapists that everybody holds something back, right? We're not going to get the whole story, but at least we hope they'll be honest enough that we can do something to help them, whether that's through psychotherapy, through medications, or other psychosocial approaches. And so they have to know we're going to protect their information, right? HIPAA, 42 CFR Part 2 for the substance use disorders, et cetera. And then we have the ethical obligation to preserve that confidentiality, right? So it's a two-way street, right? They have to be able to trust us, and then we have to give them a reason to trust us. The APA has a similar concept here, that we respect the rights of patients. We will safeguard patient confidences and privacy within the constraints of the law. Obviously, we always have to follow the law. There are times, as you know, that we have to break confidentiality. Some of them are pretty straightforward. Gunshot wounds, right? If someone goes to an ER with a gunshot wound, it gets reported. But that gets police involved. We want to know who's using a gun and where, especially in the current environment where there's more gun violence. We need to know that. Abuse type cases, neglect type cases. There are places where we have to. There isn't even it's not just permitted, it's required, right? But APA and AMA both permit the breach of patient confidences when you're mitigating a threat of serious physical harm, not just a propensity, as in Volk. So Volk is still very slippery as a slope here. I made this red on purpose. So the conflict is that Volk's requirement for clinicians to take measures to protect anyone who might be foreseeable endangered likely will encourage clinicians to start making all sorts of disclosures, right, to others, to believing they're protecting themselves from liability. And of course, eventually you're eroding patient confidentiality. No one's going to tell you anything. Now we're not really able to be in a position to do a good job to protect the public, society, if you will, as the laws usually say, from dangerousness of our own patients. The patients, of course, if we do that, are going to face possible embarrassment, other negative impacts, and again, slippery slope. They're going to start not telling us things, and it also, of course, perpetuates this false stigma that people with mental illnesses are typically violent. That's a whole nother lecture, but the truth is that they're not. Most crimes in this country are not committed by individuals with mental illness, or at least not even closely related to any mental illness that they have. So again, we get back to this fear of lawyers. Counselor, why in the world are you wearing a bright red shirt in court today? It's an old Army habit, Judge. I wore red shirts so if I got shot, my men wouldn't see any blood and lose courage. I see. Well, looking at the ruling I'm about to make, you may wish you had your brown pants on today. So a little bit of the nervousness that people have here with the attorneys. So here's Ohio. Let's go back to Ohio. So it was called House Bill 71. In fact, I still hear people refer to it as House Bill 71 because that's easier to remember than Ohio Revised Code 2305.51. Right. So this became effective a little over a year after I arrived in Ohio. And I was actually the only forensic psychiatrist in Toledo at the time, in that whole county, in fact, Lucas County. And so the net was I did start to hire new ones at the state hospital eventually. But what happened then was amazing to me, because many people who paid any attention to the first two cases I showed, including the 1997 case, the ones who paid attention to that were already nervous, as they should have been. Many people had paid zero attention. So I encourage you, my point here is, please pay attention to these types of things. Now, I think we do a much better job now than they did back in the 1990s, because it comes out in all of it comes out in the, somebody mentioned the board. So the pharmacy board and the medical board and the social work board and the family, marriage and family therapist, I guess, is board. But all these boards are pretty good now at putting this stuff out. So you're going to hear about it. You're going to hear about it from a professional organization. That really wasn't true back even in the late 90s. So this became effective, and suddenly from all North Coast, we had all of the counties, from the Indiana border to the Pennsylvania border. Suddenly I and several of us were getting calls, please come give us a talk about this. We're very scared now. And the reality was what took place in September of 99 was awesome for us as providers. So what it says is a mental health professional or a mental health organization is liable. It's going to be some legalese here, the way they jump around, but let me stop there first. Mental health professional. Who is a mental health professional? Anybody who treats a patient for a mental health condition is, under the law, a mental health professional. If you're an OBGYN and you give Prozac to the mother, you are a mental health professional. If you're family medicine, like Dr. Ballister, and he obviously does treat patients with mental illness, same thing. Dr. Lackritz, pediatrics. She is a mental health clinician, mental health professional, but she gives, any of the rest of you who are on here, other than maybe so far the medical students, but soon you will be a mental health professional if you treat any of your patients, no matter what specialty you go into, for a mental health condition. So just be aware, that's why this is broad, and I don't believe still that they teach this in any residency other than psychiatry. And I know they teach it at least in our psychiatry residency, because I asked and they agreed and I teach it. So I know they do it in the SUMA residency. So a mental health professional or mental health organization is liable if they don't, so again, some legal jumping around here, predict, warn of, or take precautions to provide protection, hence duty to protect, from the violent behavior of a mental health client only if the client or a knowledgeable person has communicated an explicit threat of inflicting imminent and serious physical harm. So it's got to be, again, this dials it way back from the slippery slope. It's got to be explicit. It's got to be physical harm. It has to be a clearly identifiable potential victim or victims. And, which I love this part, you have to believe, you as the clinician have to believe the client actually has the intent and the ability to carry out the threat. And if you have all those things, you then have to do something about it. You then have a duty. So let's step back on that a second. So if one of my private patients comes in and tells me that he had a dream about killing his brother, I'm going to obviously explore that. I'm likely going to identify that it was just a dream. He's got no interest, and he's actually telling me because he's bothered by the fact that he had the dream. That does not attach a duty because he doesn't actually have the intent to carry that out. So, but you want to document that, of course. If you're going to document the dream, you better document that you also went through it carefully enough to see no intent. I keep looking over here because all your pictures are over here. Anyway, so you document the intent. So just to be clear of that. On the other hand, let me go to the other place. Let's say that the same man comes in and tells me he's so angry at his child's school bus driver who comes by 5 days a week, and he tells me he's going to kill the bus driver. That is identifiable enough. He doesn't have to give me his or her or their name, date of birth, and social number. Okay, I as long as I'm clear who he's talking about, I do take that as identifiable, right? So just to be clear, as you look at these, you've got to pay attention to what might they mean, what might they not mean. I'll give you another example. When I used to moonlight in the prison, obviously I was seeing people who had criminal propensities. They were all there for that reason. And it was a high close security. They were all serious crime. They were not drug possession or even drug dealing. It was always violent type offenses in that setting because it was just below maximum security. And they might tell me that they are still angry at their ex and they're going to get out and it was an all-male prison. They're going to get out and kill her. Well, guess what? They weren't getting out. They had no ability to carry it out. I don't have to do a duty to protect in a circumstance where it's clear they can't. Her person in a nursing home doesn't have the physical capacity to leave the nursing home. You don't have to do this whole duty to protect them, right? You're going to treat them. You want to make them feel better. You want to help them with their anger. Maybe it's due to other mental illness issues. But so we can walk through more if you have questions. But just to be clear, what does this really mean? So how do you discharge your duty? And again, Ohio law, excellent at this. It tells you exactly what to do. And if you do this, you will not lose a lawsuit. Doesn't mean you can't be sued, but the law basically guarantees if you follow this, you will not lose a lawsuit. And I'll come back to that at the end. So you can hospitalize them. Logically, that makes sense, right? Pink slip, whatever you need to do against their will, get them in there. By the way, you could also hospitalize them voluntarily. Still emergency, but clearly to keep your therapeutic alliance would be great if I can get Mr. Jones to agree, yeah, this is probably pretty stressful. Maybe you're better off going in for a few days. And most people realize it is a few days. You're not going to get nearly the length of stay you might hope somebody will get in the hospital. So you want to, maybe they'll agree to go in. I've done that with some of my patients, and that worked. That actually was very good. And they came back to see me when they got out and everything was okay. Establish and undertake a treatment plan. This is in the law, calculated to eliminate. I love that phrase. Calculated to eliminate the possibility. So it's clear they know, the lawyers and stuff who wrote these things know, we can't guarantee that we're going to eliminate the risk. We don't have that level of control, but we can at least do our best under the current science to calculate the ability to eliminate the possibilities. I love that. That's actually in the law. That they will carry out the threat, and here's very protective, get a second opinion from the medical director of the mental health organization or an outside licensed professional, maybe you're in private practice, what have you. Let me mention that for a second. This law had very good forensic psychiatrists at the state level who helped work on this law. So it actually got really good legal advice as well as clinical advice, high-level clinical advice. And as a result of that, it's really solid. So why is a second opinion so important? Well, that's because simple, because that's all another lecture. If you're sued, what happens is the side against you gets at least two clinicians to say you were below the standard of care and you therefore is an error, therefore it's your fault, basically. That's a simple version. If you've already got a second opinion at the current moments, which is much more powerful than Monday morning quarterbacking, and they agreed with your plan, it's really hard for them to win the lawsuit. It's very protective. So this was awesome that this was put into the law. You can also inform law enforcement, and if feasible, each potential victim or their guardian, if they're a minor, and you can tell certain information, the nature of the threat, who the patient is, who might be come to cause them harm, the identity of each potential victim. So you're not giving them their whole history, right? You're not going to tell them, well, last week they were disclosing sexual fetishes. That's obviously not relevant, but relevant information that might help the police do their job or the potential victims avoid harm is very important. The other part that's important is you have to consider each of those items and document why you chose to do it or chose not to do it. So it does take a little extra documentation. So again, let's go back to that. If you didn't hospitalize, document why. The why, of course, might be that you chose number 2 and maybe even number 3. This is really, first one's actually 2 because it's hospitalized involuntary, hospitalized voluntary. But you say, no, I didn't need to hospitalize because I've got a treatment plan. It's calculated to eliminate the threat, and my medical director, she thinks it's awesome. We're good. I wouldn't write awesome, but she thinks it's clinically feasible. And then law enforcement and or the potential victims. Let's say, I'll give you a sort of an example. I had one similar to this, so I didn't have to do a duty protect in the case. But let's say you've got a husband who constantly threatens to hurt the wife. So I bring him into couples counseling, and I'm aware through the couples counseling that the woman, the wife, kind of takes no guff from anybody. So let's say now the man comes in alone and he tells me he's going to kill his wife. Now, I know he doesn't have the intent because this is the 50th time he's done it, and we walk through it carefully. I'm feeling pretty good. But let's say for the sake of argument, I'm a little more concerned this time. And I document why I don't think it's going to be hospitalizing, but I say I want to tell the wife, which I'm allowed to do under this law. But I know if I tell the wife that when the husband gets home, she is going to be like, pardon my French, you're such a weenie. You would never hurt me. You're just this tiny little man. You're never going to hurt me. So if I know that she is going to escalate him and possibly then get hurt, I don't have to tell her. All right. So there are times where you would document, I'm not going to tell the potential victim because they actually might ramp up the likelihood they're going to get hurt because of what I know about them. You don't always know that, of course. Again, that's this piece here about it, the danger piece. And you are not liable for disclosing any confidential information. Obviously, if you go too far, someone try to raise a stink. But the bottom line is, if you've got to say more just to get the police to think about it, that's fine. The law has one flaw that I've found, and that is it doesn't say what law enforcement to inform. So let's say your patient comes to see Nicole in Rootstown, but the potential victim lives in Akron. Do you call the Akron Police Department? Do you call the Rootstown Police Department? Do you tell the Neomed? All right, you get into this. There's nothing in the law that says who would you tell. And I will also tell you, when I mention this to CIT training to officers, they look at me like, huh? What do you expect us to do? Because they don't have enough personnel to go sit outside any one of their homes and see if something happens, right? So that's actually not a good choice. I'm just putting that out there. I wouldn't choose that option, at least not as the only option. I would be more likely to either, if you're really concerned, hospitalize voluntarily if they'll do it, or do the treatment plan and maybe warn the potential victim if you think that'll be helpful. You can tell the police, but I can assure you and it's not their fault, they're not trained on this either. They're not going to do anything. So here's a quicker summary, right? So it's got to be an explicit threat. It has to be a clearly identifiable victim. You have to believe they have the intent and the ability to carry it out. And then you can hospitalize emergently, which could be voluntary or involuntary. Treatment plan with consultation, document. That's not just a curbside consult. You want to document, I spoke with Mr. or Mrs. Doctor or whatever, so-and-so. Here's what we discussed. Right. So just be clear about that. The informing the police and potential victims and documenting each of these why you did it and did not do it. The great news is that at this point, since 1999, and I did look into it again, as far as I can find, no clinician has been sued for failure of duty to protect. So it's very protective. Basically, even attorneys don't want to take the cases. So I see that Pedro put one question in. Should we document the criminal record that was recently released from jail? That's a great question. So I do. I mean, it depends on your bent. As a forensic psychiatrist, I always ask about legal involvement. And yes, I will put down anything that I think might be relevant to future issues. Right. So you don't have to write a lot, but there's certainly no negative of mentioning Mr. Jones. Let's put it this way. Likely, if he was in prison, having moonlighted in the prison and did direct care, you can find out, did he get psychiatric care in the prison? And if he did, that's very relevant. Mr. Jones released from 3 years at Toledo Correctional Institute. That's where I was moonlighting for a decade. You could even write on an offense of X. He received treatment for whatever diagnosis while in prison. Absolutely legal to do it. There's actually really no HIPAA attached to the fact that he was in prison, because honestly, you can look that up right now online. I can look up anybody who's been ever in the Summit County Jail online. So that's all public record. So anything more to your question?
Oh, yeah. So I had this new patient, uncontrolled diabetic.
Mhm.
Okay. And he took, like they were just giving me metformin in prison and I didn't like it. It didn't work. So why were you in prison? It's like, I don't have to